The battle of wits and the choice of words could perhaps best describe the intellectual clash of legal minds at the Supreme Court during the pre-trial conference on the presidential election petitions on Monday and Tuesday. This was the beginning which gave way to hearings on Wednesday and Thursday and a special sitting on Good Friday to deliberate on the findings of a scrutiny of all Form 34 and 36 that were used during the general election as ordered by the Supreme Court judges. And even as Kenya awaits the final verdict on Saturday, from the beginning, each lawyer marked their territory and argued their cases before the 6 Supreme Court judges.
My lords, my learned senior will have his time to respond. He must sit down. He's my senior, but he must sit down.
Could go too far if one is introducing new evidence in their submissions.
My lords, senior counsel will have his opportunity. This is a petitioner's day in court. Surely he must sit down.
I think really what we are seeing is that a clear evidence of an implosion in that petition. And what my learned friends are doing is a reconstruction of that case.
My Lord, we are back to 2007 scenario, where forms are left in the hands of the returning officers to do whatever they wish to do.
For some, controlling their temper was a major challenge.
The process has been opaque, it's been clumsy, it's been inefficient, it's been inaccurate, it's been unaccountable.
This young man should not look up Roger Tesaros, find a word like opaque, and find every other word that means the same, just to show off to this court that he knows a little English.
If you are unhappy or you are very angry, don't pour it out here in court.
I'm sorry.
You must respect the counsel.
I apologize.
For the learned friends, light moments such as the debate on dress code in between the arguments eased the intellectual tension.
By the way, I wanted to tell you that you know, you don't have to wear that gown, and you can just wear a suit because you're going to start sweating in here. It's very hot. Smart suits.
I'll be guided
by
you, my lord. Thank you.
And of confirmed and declined friend requests.
May I request you, my lords, now that I am a friend of your court, to include me among those people whose views you may seek.
And with limited time, each one of them had to argue their case within their allocated time and defend their client.
Daylight theft or night theft. My lord, the only logical finding that this court can make, I dare say, about the results of Nyeri County is to vitiate the entire results of that county. Anything else offends the reason why Kenyans stood in line at the referendum to bring in a new constitution. This is what we wanted to stop.
That video, I don't know where it was recorded, probably River Road. Yes, she cannot disprove that that video was stage managed or recorded in River Road. I don't know what it was. I was the closest person sitting to it, and I watched it from the laptop. And I think it was of no property value. And with tremendous respect to her, the less I say about it, the better.
And to the Form 34 and 36 argument.
Forms are left in the hands of the returning officers to do whatever they wish to do.
Emphasis in these submissions is to say that the arguments that the register must be one is not founded in law. The law contemplates and expects more than one register.
But my lord, I think, my lord, as someone who knows one or two things about computers, he has a screensaver to say that no matter what happens in every election, his votes are stolen, whether it is 1997, whether it's 2007, or whether it's 2013. The only thing that changes is the year.
Parliament has enacted 256 laws, as the former Minister for Justice will tell you. And he's here.
They have argued their cases, defended their clients. The verdict now lies entirely on the 6 Supreme Court judges. Judy Kosgei, Citizen TV, Nairobi.